Ladies and gentlemen, good evening. Welcome to the Royal Brisbane Hospital Charity Event Fundraiser. It is with much pleasure and gratitude that we welcome you all here this evening. Without further ado, I'd like to introduce our first guest speaker tonight, Professor Michael Pommer. Professor Pommer is an advocate of human rights and is passionate in the areas of law, medicine, and biology. Please welcome Mr. Pommer. Good evening, ladies and gentlemen. It is with pleasure that I join you this evening to support the Royal Brisbane Hospital and the important pursuit of cancer research. This evening, I'd like to speak about a topic that I believe is important for our own awareness and for the promotion of human rights. As technology advances at a dizzying pace, so too do advances in medicine, and somewhere in between stands you and I. So on this ever-evolving landscape, we have to take a strong foothold and determine where we stand and what our rights really are. Not only in the interests of individual privacy, but for the health and welfare of the next generation. At this point, I would like to take a sidestep and introduce you to a concept which we're all familiar with. This is the concept of property. I've always found it helpful to conceptualize property as a bundle of rights, as opposed to a tangible or even intangible object. In fact, the concept of property to me is characterized most accurately by the ability to exclude other people from accessing a particular thing. But how does property relate to the field of science, I hear you asking? Do you believe you own your own bodies? Do you believe your body is your property? And who owns your body if you die? You may be surprised to learn that for decades it has been well known, according to common law, that there is in fact no property rights in body parts or products, or even the body of a deceased person. How do we feel about this, ladies and gentlemen? Well, while you ponder these questions, I would like to relate the facts of a court case to you all in order to give these questions some context and hopefully give the meaning of property some clarity. The court case is Baisley and Wesley Monash, IVF Pty Ltd. Mr. Baisley was diagnosed with cancer and faced the need to undertake chemotherapy. Before this was to take place, the doctors advised that he take a sample of his semen and store it with a medical facility in case the forthcoming treatment had an adverse effect on his fertility. Mr. Baisley did just this. However, shortly thereafter, the cancer spread and he passed away. His wife asked the hospital to give her the samples that her husband had produced, but they refused. The hospital said that in the absence of specific reproductive and assisted technology legislation in Queensland, the hospital would act in accordance with National Health and Medical Research Council guidelines. The guidelines state that clinics must not facilitate the use of gametes to achieve pregnancy unless a deceased person has left clearly expressed and witnessed directions consenting to the use of his or her gametes. Without this consent, the hospital was under a legal obligation to destroy the samples. The hospital produced a document to this effect which Mr. Baisley had signed. So, ladies and gentlemen, as we now know, the common law holds that there is no property in bodily tissue, which would include cryogenically frozen sperm samples. Do you believe the hospital should destroy these samples and prevent Mrs. Baisley from having them? Well, the judges in this case asked an important question. Can we really compare a corpse awaiting burial to Mr. Baisley's frozen sperm? To begin answering this question, another famous case was used as a comparison. It was the 1908 case of Doodwood and Spence. In this case, a man named Doodwood had come into possession of a two-headed baby which had been stillborn. He preserved the fetus in a jar with spirit and intended to show it as a curiosity. The local police seized it, whereupon Doodwood appealed and demanded its return. In the resulting legal dispute, the prosecution argued that because there is no right of ownership in corpses, Doodwood had no legal right to possess one. The court ruled that the body should be returned to Doodwood because it had undergone the lawful exercise of work or skill. It had actually acquired some attributes, differentiating it from a mere corpse awaiting burial. In other words, since the body had been preserved in a bottle with spirit, it should no longer be considered a non-entity and was therefore legally protected. Dudewood therefore gained a right to retain possession of the corpse as against any person not entitled to have it. And at this point, I'd like to return to the concept of excludability, as I believe that this is indicative of a major characteristic of what we can define as property. A principle which has arisen from other cases, such as Victoria Park racing, is this principle that a resource can be propertised only if it is excludable, and a resource is excludable only if another person has control over the access of strangers to the various benefits found in that resource. In fact, one of the important questions raised in Victoria Park racing was whether property had in fact been stolen. The concept of property was explored by asking whether the defendants were guilty of misappropriating something which the plaintiff has created and alone is entitled to turn into value. And it is these last words of this sentence which resonate most closely with the questions we ponder this evening, ladies and gentlemen, and that is something which has been created and is entitled to turn into value. This is the essence of the questions we ask ourselves and the basis for which the judges form their conclusions in relation to Mrs. Baisley's predicament. Even if not governed by the general law of personal property, it was said that the Viles occupies a category that entitles them to special respect because of their potential for human life. In other words, the value in sperm lies in its potential to create a child. It therefore defies reason to not regard tissue samples as property. Such samples have a real physical presence. They exist and will continue to exist until some other step is taken. And as far as the rights of Mrs. Baisley are concerned, it follows as a matter of law that the ownership of Mr. Baisley's DNA is vested in him while he is alive and in his personal representatives after death, this being Mrs. Baisley. So it might be argued that our cells remain our property and no one else's, but in recent times, it appears as though the need to protect our property rights is becoming more and more important. Researchers, medical practitioners, patients, families, the community and the police, among many others, all have interests in human biological materials, each at times wanting control of or access to that material. Changing circumstances may lead to samples collected and stored for one purpose being subsequently used for others. Technological advancements have meant an extraordinarily sophisticated use of human tissue in more and more areas of medicine. Additionally, such advancements, for example, 3D organ reproductions from human tissue, are occurring at a rapid rate. More and more, the questions surrounding the legal ownership of human tissue and cells are being impacted by such advancements. The overlapping of science and technology and law has become progressively more complicated to separate and define. I thank you all for listening, and I hope you enjoy the rest of your evening. Thank you.